represented here can come with an agreement on what should be done, particularly to somebody who is seeking higher office of accountability and has refused to be accountable on previous years, should be dealt with. That is how we are here, and we initially wrote even to DPP in the first year. I think DPP must have handled, and all the arms of government must have also had. We decided also to call IBC because this is the season when we are supposed to be cleared to stand for high offices, all of us. And one prime objective, if you refuse to be accountable to the people of Kenya, and particularly where funds is involved, whether one can still be allowed to be trusted to sit in a position of such authority. My chairman can add, because he also been seized with the matter, and then we can allow us for deliberation.
Thank you, Ben. I think the only thing I need to add, which is very important, is that there are institutions of governance which are given certain powers in this constitution. And one of those institutions of governance is Parliament. And Parliament works through two houses, the National Assembly and the Senate. And both houses are what are called standing orders, which stipulate how these two houses work in line with the Constitution. And therefore, what the Vice Chair has read with regard to powers of this committee is derived from the position given to institutions of governance in this Constitution. Once one institution does not cooperate with another, it raises a lot of issues of observance of this Constitution and therefore proper governance in the country. And I do believe that the reason why this committee has called other institutions to deliberate on this issue is because in the final analysis, these are the institutions that are here today must work in tandem with us in implementing accountability in governance, in devolved governance. Now, it's very, very clear in Article 96 that the Senate as a whole is given the responsibility of looking after the interests of counties. And to be on record, I'd like to quote Article 96, because that article provides the constitutional basis on which the two houses function, particularly the Senate with regard to counties. And let me read. The Senate represents the counties, and serves to protect the interests of the counties and their governments. 2, the Senate participates in the lawmaking function of Parliament by considering, debating, and approving bills concerning counties, as provided in Articles 109 to 113. And thirdly, the Senate determines the allocation of national revenue among counties, as provided in Article 217, and exercises oversight over national revenue allocated to the county government. Exercises oversight. That's a constitutional function. And fourthly, the Senate participates in the oversight of state officers by considering and determining any resolution to remove the president or deputy president from office in accordance with Article 145. Two committees are extremely important in the oversight of financial responsibility in the counties. One is the Finance, Budget and Commerce Committee, which is a supply-side committee. In other words, it supplies money to the counties. Once it does that, then the Senate Public Accounts and Investments Committee must ascertain that those funds are used in accordance with the Constitution and the other laws that exist in government. Therefore, if we don't do something about the fact that governors must come before this committee so that we can do our oversight role, we shall ipso facto be undermining the Constitution. So I think this committee is extremely important to discuss this issue and therefore dispose of it in a manner that will set precedent for future committees of the Senate. Thank you.
Thank you, members. That is the agenda. Members of the committee, we can adapt the agenda. It's a long agenda, but rotates around one individual. Yes?
I propose.
Propose Senator Martha.
I second.
Second, Senator Lisa Chelule. Members, indeed, we are here, and we want to ask DPP, because you are seized of the same matter, to maybe to brief the committee of the previous one of 2013-14 went, and where it stands now.
Thank you, Chairman and honorable members. I think a couple of issues. This matter has been a subject of discussion before this committee and deliberation between the committee and ourselves and other coordinate agencies for many times, numerous times. And not just this matter, I think, this specific case, I think other cases of similar nature. And the impression one gets out of all this is the utter helplessness and impotence on the part of this committee, which is a tragedy. It's a tragedy and a total subversion of our constitutional democracy. There's a reason why the people of this country, in promulgating the Constitution provided in Article 96, that Chairman you referred to, established the Senate, the National Assembly, and gave them the power to oversight. You are coming to the end of your term in the next couple of weeks, months, I don't know. And these issues need to be resolved for the sake of the country and for the sake of the incoming parliament. Accountability is deeply entrenched in our Constitution. Those who have the responsibility to manage public resources have a constitutional, legal, moral, and ethical duty to be accountable and transparent in the manner in which they discharge that responsibility. And that includes the governors. And the law, the Constitution establishes accountability mechanisms. And such mechanisms include the Office of Auditor General, who has done his bit in regard to this and other similar cases, and the oversight committees of the National Assembly, or of the Parliament. Coming to this matter, because there are a lot that I need to say, and I would like to say, but just to be specific so I don't take too much time. Regarding this matter, as you know, when I received communication from the Clerk of the Senate, I directed the Director of Criminal Investigation to compile the file, which he did. Timelessly, I made a decision to prosecute, to charge. And from then henceforth, this matter has been pending before the court. Constitutional and legal issues have been raised, and the matter has been consolidated with another matter concerning the governor of Meru County. and the cases consolidated have been heard and are scheduled for judgment on the 21st of June of this year. I am therefore constrained in what I can say about the merits or demerits of the arguments that had been placed before the judiciary, lest I am found to be held to be in contempt of court. So that is the clarification, Chair, as regards the specific matter that you've referred to. As to the wider question about generally what should be done, that I will be prepared to give my thoughts about it, I think, in the course of these deliberations. Thank you, Chair.
Thank you. Senator Martha.
Thank you, Chair. I think the DPP has really captured our frustrations because this is a matter we have ventilated about, even on the floor of the House. We have toiled with it for the last 3 years. In fact, some of the issues that were raised even in court by Governor Oparanya, he actually objected and said that Senator Halwale was the chairman of the committee. Now he's not even the chairman of the committee, so it had nothing really to do with who was chairing this committee. It is something that he has made up his mind that he won't be accountable. And it is quite unfortunate because even as we wind up our term, we still don't have a way forward. But I am more interested, even without getting into the details of the court cases that are pending, to the IEBC. I think the other time we have deliberated on these matters, we have not included IEBC. And I don't know whether the CJ is represented, the Chief Justice, because we really needed the cooperation of the judiciary to be able to unlock this problem, because it is a precedent that has been set and will be very dangerous even as we go to elections. But on the issue of IEBC, and this to the legal officer, in the IEBC Act, Section 4J, in the development and enforcement of the code of conduct, because we must get a way of dealing with it somehow. And if we cannot get it through the process that is already being undertaken, then we must think of other ways of skinning the cat. And my thinking is that the code of conduct, if it is properly implemented by IEBC, we should be able to teach a lesson to characters like Governor Oparanya, really, who have defied the Constitution, ran away from accountability. In fact, when you look at the audit reports of Kakamega, you really feel ashamed that we have not been able to get answers for these queries. In fact, in one of the trade ministry, and I know you have looked members at these audit reports, a whopping almost 214 million is not explained. If you do that in 25 audit queries of 2013-2014, if you do that with 2014-2015, we are talking millions of money. So I would like to hear from the IEBC representative that are we able to enforce this so that we can bar someone from actually being cleared by IEBC if you're running away from accountability, because it's really not a choice. It's a constitutional obligation.
Yes, Senator Matangi.
Yes, Chair, thank you. I want to first also thank the entire teams that have come this morning upon the invitation of the committee. And Chair, just to follow up and also echo not only the words that have been said by the DPP, but also by the Chair here. But in saying so, also ensure that we are also loud enough to say that the Constitution is not ambiguous about how we should proceed with issues, with matters of failure or non-compliance with Chapter 6 of the Constitution. And because the Constitution is the supreme law of the land. And Chair, this committee, in the presence of all the stakeholders in this meeting, needs to proceed alongside the lines where we should be seeking to make a determination on the matter. Because, Chair, as I say, to the Mwananchi, just like to anyone else, justice delayed is justice denied. And the people of Kakamega have sought to have justice on the question of the accountability of the monies which have been given to the governor of Kakamega for the last 4.5 years, Chair. And it is important to put on record that as of this date, not less than 30 billion Kenya shillings have been sent to the county government of Kakamega under the guidance and under the authority of the current governor. And Chair, with the provisions of the Constitution, I feel and firmly believe that this meeting should be taking a direction towards asking all the stakeholders who are here, and more so the IABC themselves. Now that we know the provisions of Chapter 6, now that we know the implications of the law and all the acts from the Public Finance Management Act to the County Government Act, Mr. Chairman, what we should be saying to the IEBC at the end of this meeting, in light of what has been said and also affirmed by the Director of Public Prosecutions, is the IEBC going to be receiving and accepting papers that would be proffered or given by one such as the governor for Kakamega to be deemed to be papers that can be used to clear a candidate to run for office of governor in a county on the basis that that person complies with the constitutional requirements of this country? That should be the question. And in spite of all the tricks and games, Chair, that have been played for those last years, Mr. Chair, all these institutions cannot fail to come up with a solution. And more so, IBC, in my view, cannot also sit or hide behind the curtain that they will be still waiting for another determination other than what is known in law, that for one to have complied with the law, Mr. Chairman, then they must have been first of all accountable and seen and known to be accountable, Mr. Chair. So the question that we will pose to IBC, and I would want personally to pose to IBC, is, will the name of the governor, current governor of Kakamega, be on the ballot paper of the Kakamega governor if he continues and has continued to defy, just on the pretext that he will be a clean man to run for a second term?
Yes.
My understanding is that all the institutions represented here this morning have received a brief from the Senate on why they were invited here. So I want to request, as a matter of procedure, that just in the same manner as the DPP has put his word on Hansard, we also allow the other institutions to do so before and then we seek to clarify or urge them to move in a particular direction. I beg you.
We are coming in that direction. Let's hear from Senator Nyong'o first.
Let me just underscore what Senator Alwale said. I think the DPP made a very, very good point. He lamented that this committee seems to be impotent. That's a very serious word, you know, especially when the king is next to me, and the king is supposed to be the most important man in the world. You know, that's it, by the way. I think the DPP made a very important point that for him as an office, he's waiting for the court case on the 21st, after which he can then make conclusive statements about this, because he cannot, since he's in the process of in which that case is being determined by the. But as Alwale says, Senator Alwale says, we need to hear the positions of the constitutional officers. Remember my remarks regarding Article 96, that unless institutions of governance play their role regarding various constitutional responsibilities they are given, then we can easily not reinforce each other in implementing the Constitution. As far as we are concerned, we are given this responsibility in Article 96, but we cannot really fulfill Article 96 unless we cooperate with other institutions or work together. One institution is the Auditor General, who gives us his report every year regarding accountability. Our responsibility is then to call the governors to discuss the Auditor General's qualifications and to determine whether indeed they stay as the Auditor General has said, or we are given more information that can clarify these statements. Now, when a governor declines to do that from one financial year to the other, is he respecting his constitutional responsibility? And what do other constitutional officers say about that to help us solve this problem? I think this is the key to Alwale's request. So it would be good if we could hear from you, taking the cue from the DPP, so that then together we can find a solution. I suppose we are very clear on that. Yeah, please.
So for that reason, let's hear from the Auditor General. Auditor General.
Thank you, Chair. I appreciate the gravity of the matter that the committee is considering in the interest of accountability for our country. And as an office, our clear mandate is to look at all public entities and the resources that have been entrusted to them and report thereon as per the requirements of the Constitution, Article 229, both on the financial statements and on the effectiveness of the use of those resources, their efficiency, and their economy. In particular, in respect to the County of Kakamega, we have delivered the reports for 2014, for 2015, and we are just about to release the report for 2016. I can confirm that consistently the reports are not good because they enumerate quite a number of issues that are not explained. And from where I sit, it is true that either the county government of Kakamega has challenges in terms of having the capacity to prepare, maintain, and report on their financial management, because that is what you see when you see a number of issues in the reports therein. That has of course been an issue between us and the county government of Kakamega in terms of responding adequately to those issues, and the reason that they are not adequately responded to or explained, they end up in the final audit report, which the Auditor General has signed on the county. One of the issues that we are also following closely is the issue of non-implementation of audit recommendations. Because as we do the audit work between the Office of the Auditor General and the auditee, there's a clear understanding that there are issues, there are gaps, there are challenges which needs to be fixed. And therefore, as the audit process continues, as the Public Audit Act 2015 spells out in section 31, the auditee is under obligation to fix those things. But if you look through those reports over the last 2 years, 3 years, it seems to have a pattern of issues that keep recurring. The recurrence means that a number of those issues are not dealt with, because if they are dealt with in the first year, then the second year you expect that you will have a lesser number of queries or different nature of queries. But the consistency of the nature of queries that are coming means that they are not adequately addressed. This may not be a particular problem for Kakamega County alone. It's spread across many entities where some issues keep recurring because of some inherent challenges they may be having, or lack of serious action on the audit recommendations. So therefore, in this particular issue, we are with the committee in terms of finding a critical way forward in ensuring that not only the county government of Kakamega, but every other entity with public resources accounts for its resources to ensure that the people of Kenya get the services that the Constitution allows them to get out of these resources. When I read through the Public Audit Act in relation to the Constitution on this subject, it's clear that this committee and the Senate as a whole and Parliament as a whole has the responsibility to look at those issues of oversight and make recommendations. But one thing that struck me when I was looking through this is the issue of where a member or an OTT refuses to appear before the committee, it creates a question of contempt. And if it is contempt of the committee, in the light of Article 75 of the Constitution, can that be taken to be gross misconduct? Can it be taken to mean abuse of office, which then means a serious other resolutions? That is some of the issues that I was looking through that the committee may seek further legal advice on in making a decision on this area. Of course, the Public Courts Act and the Constitution allows that where there is mismanagement of resources, the Auditor General can make a recommendation for withdrawal of funds. But in this case, that is a wider issue. We need to look at, is it the county that has failed, or is it an individual within the county? How do we separate the issue of the individual from the county government and its operations? That is another issue that comes to fore when you consider the subject matter that we are discussing. I know the other entities have issues to comment on. I will want to say that as an office, we are ready and willing to continue the accountability journey despite the challenges, because sometimes when we get to this kind of situation where we are, which appears like it's a dead end, it actually frustrates the staff that work in these entities. Because when you go there and the OTT feels like nothing happens when you raise these issues, it actually creates a situation of some frustration within the effort. And that, of course, curtails the efforts of staff. But notwithstanding this, the assurance I want to give the committee is that the Office of the Auditor General is stretched in terms of resources, is stretched in terms of capacity, but with what we have agreed to do more with less to ensure accountability is ensured. Thank you, Chair.
Thank you, Auditor General. Can we hear from the Controller of Budget?
Thank you, Chairman and honorable members. As an office, I will speak from a general view that our mandate is to promote prudent use of financial resources in the country. And as correctly captured in the mandate of this committee, we do submit reports to the committee on a quarterly basis. In drafting these reports, we rely on the Integrated Financial Management System reports, which we extract, as well as individual returns from the counties. In those reports, what we do, we track. We do make recommendations, and on a regular basis, we do track the progress that the counties have made in terms of implementing our recommendations. I can say that in a number of cases, we have noted that some counties are non-responsive. There's an aspect of non-responsiveness where we identify and make recommendations, but those recommendations, after another reporting period, you find they are still outstanding, they're yet to be addressed. What we have done in the last hardly 2 months, we have written to all the counties pointing out the need for them to submit financial and non-financial information to us on a regular basis as envisaged in Section 166 of the Public Finance Management Act. So it's a matter that we've kept on following up with the counties to ensure there's responsiveness and to ensure that public financial management is upheld and the individual institutions are very responsible. That is our goal. In terms of discharging our mandate, again, what we have done, there are instances where we come across matters that we elevate. There are some matters we have elevated and reported to other institutions, which we collaborate closely. Whenever we get matters that we think are warranted to bring to the attention of either ESCC or the Auditor General, we do that, so that as they undertake their other mandates, they can be able to consider those matters. So generally, as an office, we are trying in as much as possible to ensure that the space of promoting prudent use of our public resources, which are scarce, is upheld by all players and in conjunction with the other institutions that I have mentioned. Thank you, Chairman.
Thank you. You will furnish the committee with the extract. The one you normally prepare for counties, but for this particular one for Kakamega, year 1, year 2, the way you normally get the summaries, the analysis. Yes. Can we listen here from the IEBC?
Thank you, Chair. On behalf of the IEBC, I wish to state from the onset that the CEO informed me that he wasn't sure as to why we had been invited to this meeting. So my instructions was to come and listen and find out why we were invited to this meeting. Having said that, however, the Commission is charged with the responsibility of conducting elections. The Commission is charged with the responsibility of ensuring that the constitutional provisions for qualifications and disqualifications of a candidate are adhered to. And some of these provisions require that the candidate do meet the moral and educational requirements that are set out in the Constitution and other legislation, and issues touching on Chapter 6. And with respect to matters Chapter 6, Mr. Chair, as you're aware, there is the ESCC, which body is charged with implementing provisions under Chapter 6. And as for candidates for elective office, they are required to submit a self-declaration form stating their suitability to moral and ethical provisions. Hence, issues touching on abuse of office are some of the considerations that perhaps would come through the self-declaration form that ESCC would look into. As you may be aware, Chairman, the Commission has established an interagency collaborative desk and relationship, which brings on board other agencies whose mandate will be to assist the Commission, and in particular the returning officer, in terms of confirmation of suitability and qualifications to vie as candidates. Thank you, Chair.
A point of order. Yeah.
Yeah, my point of order is, of course, I hear IEBC, but from this invitation that you sent, Chairman, in fact, IEBC were the first addressee. So in terms of the matters, I think they were adequately raised in this letter and invitation. So I would expect that IEBC tells us that whether does it think that these amount to gross misconduct. I think we need just straight shooting answers. We don't need to go around. Let us hear. Does IEBC think what Governor Oparanya has done warrants disqualification? I think I would want to hear that from IEBC.
Let me just add to what Senator Wangari has said. I read in the papers. Papers may not represent what the IEBC is saying, but I did read in the papers that one of the issues that you're raising is people with cases before courts. I was puzzled because when a case is before court, you don't know how it's going to turn out. But something was said in the papers that one of the issues that Ethics and Corruption Commission is going to consider people with cases before court that relate to misconduct or abuse of office or things like those. Now, here is a case which is before court, and we have explained to you the circumstances that led to it and what the substance in the court is. And one thing comes out, when a state officer refuses to act in accordance with his responsibility, does that amount to abuse of office? In this case, the responsibility of the governor is to come before the committee and respond to the Auditor General's questions, as other governors have done. That's one. Secondly, there was a case before court regarding 2013-2014 audit issues. That notwithstanding, other audited accounts have appeared since then, 2014, 2015, and the governor has refused to come to respond to 2014, 2015, which is not before court from the facts that we have before us. Does that amount to abuse of office or declining to exercise his responsibility as a state officer as stated in the Constitution? So if you are going to raise cases before court as issues of determining whether somebody is suitable to run for office or not, here is a case in point, more or less a case study, which asks you and the Ethics and Corruption Commission, how do we deal with this case which is so concrete and so relevant to the issues we are raising? So the CEO saying that he didn't know why he's called here, to me, is a flippant answer. Because the letter says that we are dealing with the issue that you yourselves are considering in clearing candidates. It's a case in point. Can you respond to that? If you cannot respond to this one, then what you are saying you are doing regarding cases in court is actually not serious. That's my point. I was just under
Chair, can I?
You will take note. We'll give you time. Yes, Senator Matangi and then Senator Yinyagarwe.
Okay, Chair, I just wanted to add a little bit of what Senator Nyang'nyong has said, and especially in picking out with IEBC. IEBC, you know, it is a requirement through your own act of establishment and the functions of IEBC itself, and in your functions of conducting elections. Right now, as you invite us as candidates to come and tender our papers, one of the requirements is that I need to come and bring to you a nomination certificate from my party. And the process upon which you require that nomination process to have been undertaken is, one, through vetting. And having passed through, one, the integrity test, prudence in management if I'm a public officer, and all the other requirements. And if, in the first place, you do not look back and ask when we come to bring those papers, how have you traveled this journey, for example, to come and get a nomination certificate that you are going to come and produce to us? Because you see, the part that is not satisfactory is to say, for example, that until or when any other institution has declared that this person is either clean or clear to run, but in the face of overwhelming evidence that would still be in front of IEBC, that you would still not be able to act, and more so, because that would be used as a simple method of defeating justice. And lastly, as Senator Nyang'nyong says, then why go for anybody else, including all those other people with pending cases, if you call them pending? cases. This is a pending case. It is in front of the court of public opinion. It is in front of Senate and Parliament and the entire country, including the people of Kakamega.
Senator Engineer Garwe.
Thank you, Mr. Chairman. Mr. Chairman, you know, the real gain that Kenyans got from the new constitution was devolution. And Parliament had in the past tried small ways here and there, how you can set fast to the ground. And because there seemed to be some reasonable impact, we all thought that by setting these, can I call them huge amount to the ground, would make the difference. We should lift the communities to where we all were aspiring. But now it looks like we are playing around with small sounding issues, the end result of which is that we said 8 or 9 billion to Kakamega, for example, 1 or 2 billion goes into thin air, and it looks like we can keep talking third year, fourth year, and so on. So it's very unfortunate that I think there are very many issues I'd wish to probably table for discussion, but because our discussion today is very specific, let me refer one to the Director of Public Prosecution. You know, Mr. Tobiko, I'm seeing one small elephant in the room, which seems to be like the one the whole thing is revolving around, which is that we as a committee of Parliament, the Senate, we invite the governor to come and ask, to come and respond to issues, good or bad, out of the audit report. He doesn't respond, he doesn't come. Again, he doesn't respond, he doesn't come. Eventually, we said summons. Through that summons, they end up in your office, it's a court case, and the court case is not responding to the summons of the Senate. But then, the answer, Mr. Deputy, Mr. Prosecutor, Director of Prosecution, is that the governor then goes round and he then says, yes, but when the matter of oversight is being done by the county assembly, and so long as the county assembly is not finished with that oversight bit, then the Senate should not come, and that's the reason why we are not coming. And therefore, the whole matter of the constitutional review, I don't know whether that's the correct term, is that he should not have been called here in the first place. He should not have been summoned in the first place. And therefore, there should not have been a case. And therefore, now, because there should not have been a case, therefore the summon was illegal. And therefore, the court case is illegal. All revolving around this small elephant, Mr. Director of Prosecution, whether or not the Senate had the mandate or the power, if I think it's the power, because the mandate is there, to raise issues on the audit agenda's report when the county assembly is also looking at them. Because what I'm seeing, Chair, is that even if we come out of this, and then he goes back and say, originally I had told you I'm not supposed to come there. So maybe to invite a comment on this, what I would call a very fundamental, small-looking thing, which is the one which has raised all this, by maybe comment by the Director of Prosecution. I have other issues with the IBC, but maybe a comment on this one, so that we know which direction. I know you did say that there's a limited period which you can comment on an ongoing court case. Thank you.
Point of information, then Senator Galole.
Maybe this to Senator Karue, maybe as a point of information. It's unfortunate we don't have the CJ or the CJ's office, but the courts had actually pronounced themselves on this matter in terms of the mandate of the Senate, in terms of summoning the governors. It is already out in the public domain that the Senate has the full mandate to actually call governors to accountability.
Yeah, but you see, Chair, the whole thing revolves around the same. The summon came because the governor refused to come, and the governor refused to come because he said, no, whereas you have the mandate, you must listen to the mandate of this more fellow called the county assembly. Maybe I could be wrong, but that is what I've read through all the correspondence and so on. That's what I've read. Whereas the judiciary has pronounced that, yet the governor has raised an issue which is questioning the court case in the first place. So if we took that ruling that the Senate has the power, then we should not be here discussing this court. I don't know, maybe notwithstanding Senator Wangari's comment, or can perhaps let's hear what the director has to say.
Mr. Chairman, I was going to have a few issues to seek clarifications from the various institutions, and I don't want to do it now. What I want to do now is to request Madam Torore, do you introduce yourself? You are a lawyer. Yes. And I'm a doctor. I can roughly therefore say that you are a senior lawyer. You don't look like a youth. You receive...
I don't see how that relates.
You'll see very shortly. You'll see very
okay,
shortly.
fine, proceed.
I'm actually congratulating her for being an experienced lawyer. Mr. Chairman, Madam came here because of this letter. This one. Signed by the clerk of the Senate. And as a lawyer, you come and casually tell us in a formal sitting of Parliament that you don't know why you have been called here. The CEO has told you to come and find out why you've been called here. I refer you to this paragraph, which reads in the letter that brought you here, on the last page, third last paragraph, it reads that at its sitting held on Tuesday the 9th, May 2017, the committee noted with concern that once again, Honorable Paranya had failed to appear before the committee as requested, and consequently, the committee resolved to convene a consultative meeting of stakeholders to chart a way forward on how issues of governors who fail to account for public funds while in office should be addressed. This, therefore, is to invite you to participate at the aforementioned forum. And then you come here with nothing. And you are a public officer who is supposed to respond on this. I want to ask you, since you are a lawyer, and since you are aware of Article 125 of the Constitution of Kenya, specifically 25(2)(a), would you rather we listen to you as Parliament through this friendly consultative meeting, or would you like us to invoke Article 125(2)(a) so that now we examine you and cross-examine you on oath as a witness? Having said all those things, I'm asking you to respect us. What we are doing here, we are fighting corruption. And we have been fighting corruption for many years. And when you stand in the way of fighting corruption, the way I'm afraid you're sitting to appear, then you are the enemy of the people. Can you tell us whether you're prepared for this meeting or not? If you are not, you go prepare and come and help this committee. You are a pivotal institution that will be determining whether we are going to set a precedent in this country where a public officer, specifically a governor, can defy to respond to accountability and still continue serving in a public office.
Order. Lastly, Senator Lisa.
Okay, thank you, Chair. I also want to add my voice to my fellow senators about this issue. As much as Senator Kalwale is pinning on one officer, but I think with the existing institutional structures, constitutional structures in this country, There are those structures that they are supposed to address issues of revenue at the county level. And one structure is the Senate. And thanks a lot, Mr. Senator, because you did our mandate. You talked about our mandate as the Senate. And our main mandate here is to protect the county. And we have done this. And something is telling me that there is a reason why Oparanya is choosing not to come to this committee and he chooses to go to court. So all of us, we must be honest. We have institutions here. I've heard Auditor General talking about quarterly report. What are you getting from this quarterly report? Every time, especially when you hear somebody refuses to sit before this committee. What are these quarterly reports that the Auditor General is doing? So it is not about a particular or one institution. It is about all of us. We need to be honest to Kenyans. This is money belonging to the citizens of this country, and we really need to be honest to our duties. Thank you. Thank you. Thank you, Chair.
You may put off your mic. I'll give time to the various agencies present. If there is any query or clarification that touches on your office that you may need to contribute, that will be fine, but we'll start with IBC.
Thank you, Chair. I once again want to say that we respect the Senate and the role of the Senate. And again, to state, as I earlier stated, I was only called in to come into this meeting to represent the CEO only a few minutes to 10, and your office can confirm that. I also wish to state that as a senior lawyer, and a respectable one at that, I think I respect Honorable Kalwale, and I do not take kindly to intimidation, especially by citing Article 125. I respect the Senate, I respect the member, I respect all members, and I respect the Constitution. I was only being honest and clear that I had only been asked to step in for the CEO. And as a lawyer, had I had time to look at the letter, read the letter, perhaps I would have been able and be in a position to better advise this committee. But I wish to further state that if there is any issue, if there is any matter that this committee requires the Commission to address itself to, then that issue should be placed squarely at the table of the Commission, and the chairperson and the commissioners should be in a position to respond to this committee. Thank you, Mr. Chairman.
Point of order.
Order, yes.
Yes, Chair, thank you. With your permission, I wanted to introduce that as and acknowledge what the representative of IBC has said. And Chair, in pursuit of that, indeed, I felt and I still feel that it is important that for a petition to be placed directly for IEBC to be able to address itself to, even as the representative takes notes, and the petition should be that the IEBC should not and shall not accept nomination papers for the candidate for the governor of Kakamega in the name of Wycliffe Ambetsa Oparanya in the absence of clearance from all the institutions of government, including the Senate, on the accountability and the whereabouts of public funds entrusted to him for the years from 2013 to 2017. And that be treated as a matter pending in institutions of law and the Constitution, just like the High Court. And in the absence of that clearance, IEBC would be very, very hard put to address this country straight-faced and say that they themselves are not abettors of corruption or helping corrupt people pass through, such that we would be sure, and I would say that is the petition, madam, that not only that governor, but all governors who have defied, but the kingpin, the front runner is the governor for Kakamega, and he should not be allowed. It should be a direct petition to the IEBC to respond as to why should they clear an individual like that one to run for office. Why should they?
So that I can give my colleagues, we need to state that we had issues with a few governors, and eventually all of them came, and they have done very well. Machakos, Meru, Bomet, and all those ones, even Kiambu. And this is just simply accountability. There's nothing else to do with anybody, anything personal. So this one is a very peculiar case, madam. And we better take it serious, all of us. That's why it looks like you have the letter yourself. You haven't maybe gone through it. Did you want to go through it as a commission thoroughly? You understand the gravity of the matter? Because it is this serious that over 30 billion, nobody can pin a finger on. The Auditor General has gone 3 times, and you have heard what they have said. DPP has also done his. We have only one window. That fellow should not even be elected even as a village elder whatsoever, because if you have refused now accountability for anything, and even simple positions like that require accountability to the nearest people you are leading. He may be a good man, but without taking responsibility, it doesn't matter. Everything else comes to zero. Yes, let's hear.
Let me propose the following. I think we can make progress regarding what I can understand the lawyer from the IBC that the chief officer, chief executive officer, just asked you to come without preparation. I mean, yes, I could understand from your point of view that you were not prepared. Having said that, you have now listened to the issues being raised, and I think now you are more informed about the issue at hand. Let me just summarize the issue as follows. 1, to what extent is a public officer responsible to the institutions of governance as stated in the Constitution to account for public funds, especially when there are institutions to which that public officer should report? When such public officer fails to report to those constitutional offices, to what extent can the IEBC and the Ethics Anti-Corruption Commission give such a person a certificate of good conduct to be elected once more to public office? Second issue is, having taken his case to court as a way of having redress through the judicial process, and knowing that the case is going to be heard once more on the 21st of June, and hence qualifies as a case pending before court, to what extent is the IEBC and the Ethics and the Corruption Commission ready to give such a person clearance to stand for public office? Because you did state in the in papers, which puzzled me, that people with cases before court, and there's a case by the Kenya Human Rights Commission or something like that going on now on that issue. How do you deal with such a case, a concrete one? And finally, I'm going to say the following. This committee, as a committee given the responsibility of ascertaining that there's accountability of funds in the counties, and there's a clear process in law and the Constitution for doing so. When a governor declines to obey or to be subject to such laws, and you sit down with the Ethics and the Corruption Commission to clear people, how do you deal with a case like that? Because this is a concern with this committee. This committee, like Senator Wamatangi, can say, according to this committee, such a person should not stand for election. But then this committee cannot make that decision. It is you, IEBC, and the Ethics and the Corruption Commission that must make that decision. Now we have come before you, sisters in justice, with clean hands before justice to see that justice is done. Are you going to take us seriously as a committee when we bring such a case? Or do you want us to call you once more before this committee with the Ethics and the Corruption Commission to examine this issue when the two of you are together? Because we are prepared to do that. In fact, we should. Yes.
To be fair to Madam Torre, she has candidly conceded that she has not even read the letter of invitation. So I want to move the committee that you give her another appointment to come before this committee so that we can deal with the institutions that are ready. She could come tomorrow because it's a very urgent issue. We deal with it, and if you may, it would be useful if she comes at the same sitting with the Ethics and Anti-Corruption Commission. We will deal with it better.
And I would say that not just her, but the CEO, because I think we must deal with the highest office in the IBC. We don't want the CEO to outsource his responsibilities to the legal officer. The legal officer comes as part of the team of the IBC. Yes.
Chair, as I second Senator Halole, I think it's quite unfortunate. This letter is dated 16th May. I know the DPP was here at 8:30. In fact, we had to take a short adjournment waiting for IEBC, and they come unprepared. I think it's quite unfortunate, and I would hope that they take this seriously, at least read the letter. There is no other matter we need to place before IEBC. It's already in this letter. And as a way forward, Chair, I would propose that we meet IEBC with EACC tomorrow, because the clearance of candidates is happening in a very few days, yeah? And we really don't have the time. We can do that tomorrow. Please come prepared, IEBC, and we don't want to hear excuses tomorrow.
Yeah. Can you get a concurrence from the IEBC on that issue, please?
Chair, kindly. The issues that you have raised clearly, can we get those in writing kindly so that we can discuss them with the Commission?
No problem. We can send a letter today, and we shall.
Yes, thank
But
you.
we want to have your concurrence that you will be here tomorrow on our invitation with the Ethics and Corruption Commission, noting the urgency of the matter, even as far as you are concerned. We would like to help your office deal with this issue expeditiously before you are in a position to make certain final decisions. And I suppose that is...
That is in order, Chairman.
Okay, fine, good, thank you.
I'll communicate the same.
Yeah, okay. Any other comment from other institutions? Yes, DPP.
Thank you, Chairman. I think a couple of issues again here. Firstly, the issue raised by Senator Karwe, whether the point that has been taken in respect of certain cases by governors who have failed and refused to appear, that the same matter is subject of, or the same financial accounts are the subject of consideration by the by their county assembly. That issue actually has been raised. It is part of the issues raised in the Kakamega case. It is substantially the issue that has been raised in the Vihiga case, this case of Governor Karanga, where again we also made a decision to charge. That has been challenged. A stay has been granted, and the matter is coming up for hearing on the 20th of June. So yes, that issue has been raised. You cannot stop a litigant. You cannot restrict a litigant on what grounds they can litigate upon. It would be entirely upon the court to resolve that issue. But I think the senator, I think one senator actually quite correctly mentioned the advisory opinion of the Supreme Court that endorsed, acknowledged, and validated the powers of the Senate to issue summonses. So it is no longer an issue about whether this, whether the House or this committee has the powers to. It is now digging into the other collateral reasons as to why you should not appear. And I don't think there is a case now. Certainly, it is not their case that that this committee has no powers to summon. It is that the reasons, I have reasons for not appearing, and therefore I should not be charged. So that is the criminal aspect. But then, and this is important, Chair, as moving forward, it may not solve, and I'll come to the immediate issue. Going forward, I think this committee really needs to look at what we may call self-help remedies. What is it that this committee can do or should do in and by itself without over-reliance on other coordinate agencies? And I think the representative of the, firstly, under Article 125, this committee has the same powers as of the High Court to call and summon witnesses and to compel attendance. Why is it that this committee has the powers to issue summonses but has no powers to issue warrants of arrest? Has this committee ever issued a warrant of arrest? That's number one. So that then, because now the position you put ourselves in is that now we are forced to go and apply to court to get warrants of arrest, yet the Constitution itself gives you the same powers to compel attendance as the High Court. Why has it not issued, and then it become a subject of litigation, whether what is the meaning of the same powers as those of the High Court to compel attendance? Number two, and I say this with tremendous respect, Chair and honorable members, I see a bill of 2014, the Parliamentary Privileges and Powers, that is a huge improvement of the current National Assembly Powers and Privileges. It does actually, Chair, as you know, empower this committee in Clause 20, and I'll just, in Clause 20, just quickly, the power to impose fines, the committee and the House, on a person who declines or fails to, and to attach the property of that person. It gives you the powers of the court. That's clause 20. Now, the most, and this is the most significant provision also in that bill, is clause 24, where a public officer who fails to honor summonses, that public officer, and under the Constitution, that includes a governor, that includes any other state officer. And it says here, in clause 24, subclause 3, where a House passes a resolution that a public officer has contravened subsection, the resolution of the House shall constitute a ground for removal of the public in accordance with the Constitution. Yeah, so in short, what I'm asking, as I'm saying, Chair, there is a lot that this committee and Parliament can do in terms of legislating. Now, let me go to the issue about qualifications. Oh, first of all, this removal from office of a governor, I think is Article 181. Among the grounds for removal from office in Article 181 is 181(1)(a), gross violation of the Constitution or any other law for removal. Now, if you check, now what is the procedure for removal? The procedure for removal is in Section 33 of the County Government Act. and you will have to go to the county assembly. Why hasn't Parliament amended Section 33 so that in respect of disobedience to order, you can initiate suo motu proceedings for removal? Now, let's move forward now to qualifications to stand, and this is now the matter present, and I don't want to go into it. What are the qualifications or disqualifications to stand as governor? The same qualifications as those of a member of an elected member of the county assembly in Article 193. Now, 193 says, 1, unless disqualified under Clause 2, a person is eligible for election as a member of the county assembly if the person in B satisfies any educational, moral, and ethical requirements prescribed by this constitution or an act of parliament. What has stopped this House from including in the disqualification or a qualifications requirement, okay, a person who has hitherto not complied with someone says. Now, moving to sorry, this is at Article 193, G. Sorry, a person who is disqualified, no, 2G, who is disqualified. A person who is disqualified, 2G, has been found in accordance with any written law to have misused or abused a state office or public office, or to have contravened Chapter 6. In short, what I'm saying, Honorable Members, Chair, even as you, and I think you're quite entitled to express and manifest your frustration, I think there is also a lot that you yourselves should have done, and legislatively, to clarify the ambiguities in the law and therefore limit this endless litigation. Now, as regard this matter, you will discuss it tomorrow with IEBC, and it is good that EACC would be there. I would suggest that the Attorney General, who is the principal legal advisor under Article 1, be invited also to attend, because this also relates. First of all, he is the chair of the Chapter 6 institutions. Number 2, he is the principal legal advisor to government, and government includes all commissions and independent offices. So that the Attorney General is also able then to give his advisory. And by the way, in the Supreme Court matter, what the Supreme Court said, do not come straight to the Supreme Court to seek an advisory if you have not first of all consulted the Attorney General for his advice. I think it makes a lot of sense to raise the specific issues that have been framed by the Chair. That's what all I wish to say. Thank you.
Yes.
But DPP, every time I listen to you here in Parliament, I have no regrets that you became our DPP. What is disturbing me now is that this committee, there's no doubt, we are going to say one Governor Wycliffe Ambeza Oparanya is not fit to hold public office. We will not be the first to say this in the last few weeks, because even in the National Assembly, the Public Accounts Committee has also said that Anne Waiguru is not fit to hold public office. Now, having said it is not enough, what, on your advice, should we do, if anything, to ensure that what we say moves from being what we have said to being something which is enforceable? Do you mind? Do you think simply by us saying he is not fit to hold public office is enough for that to provoke IEBC not to accept his nomination papers? Or is it your advice to us that we should do more? Or rather, more should be done? Would it require that a court is moved so that that court can then make an order to the IEBC? And if so, who then should move the court? Should it be the Senate, or should it be, in my thinking, the DPP? The DPP to move the court, that in your expanded jurisdiction of understanding what goes on in public offices, you have found that a man has been declared unfit to hold public office, and therefore you're moving the court, that it orders IEBC to comply with that particular finding by the Senate, and of course by extension, in Anne Waiguru's case, by the National Assembly.
Okay, DPP.
Thank you, Chair. And I do not want to assume the role of the Attorney General. Neither do I want to suppose to advise IEBC, because it is not within my competency or mandate. But just looking at Article 193, 2G, a person is disqualified from being elected as a blah, blah, blah. If the person has been found in accordance with any law to have misused or abused of, or has contravened, I do not read anywhere there saying has been found by a court of law. Again, my personal opinion. But the authorities, about an important issue. Do you have to get a declarations by the court? I do not. That is a matter that I think should be addressed. That is a question that should be addressed to the Attorney General and to the institutions that have the mandate to clear candidates to stand.
Thank you so much. Yeah, yes, Bonnie.
Mr. Chairman, because this is a matter that we are transacting through the public, it's good for us to take advantage of the presence of IEBC here and the DPP, so that I make the following statement. From what I hear you saying is that what we have found, or what the National Assembly has found in respect of Anne Waiguru, we should go further as the Senate and as the National Assembly and write to the IEBC telling them that pursuant to Article 193, 2G, we have found that Wycliffe Ambeza Oparanya is not fit to hold public office, and therefore his nomination papers should not be accepted. And similarly, with the National Assembly, Public Accounts Committee, in respect of Anne Waiguru. Then if they refuse, we would then need the interpretation from the court to either agree or disagree with us and you that in G, it doesn't say it should be the court. It does.
Just add something. Thank you very much. Thank you very much, DPP, and thank you, Bonnie. Let me put it the following. The reason why we called these institutions is because what I said earlier, that we must all work together in ensuring that the Constitution, which people are still learning, by the way, is obeyed and implemented, particularly with regard to devolution, which Senator Karwe said perhaps was the biggest present to Kenyans from the Constitution. Having said that, this committee has gone an extra mile to validate its responsibility with other state institutions, so that together we can appreciate the importance of one another or each other in trying to ensure the use of public funds by all government institutions, in our case, by devolved government. Now, the DPP has really helped us and told us in the final analysis, what I've been looking for is actually crystallized in Article 193(2)(g). That's the fulcrum of the debate. But we need to make sure that we agree on this and we can present a coherent argument to the IEBC by now sitting together with the IEBC, with the Ethics Anti-Corruption Commission, and I'm afraid DPP, I would request you also to be in that meeting. Unfortunately, your office is being overtasked, but you seem to be actually what I would call the owl of Minerva. You know, the owl of Minerva is that bird that rose from his ashes when people thought that it had been finished. Now, we here seem to be rising from our ashes when you say that we are kind of, but you are the owl of Minerva who is really bringing us to life. So we request that tomorrow when we meet with the IBC and EACC, that you also be present so that we can finally crystallize this issue and present it formally to the IBC. IBC, on your part, I think this comes in a very timely manner because you are going to deal with such cases. And now you will find that there's an article in the Constitution where you can anchor your decisions. And this case helps to look at the various issues that may arise with regard to others. Now, the decisions that the IBC is going to make in this election is going to be a precedent to future elections. And it is going to tell public officers, don't take the Constitution for granted. These articles were not meant to be cosmetic. They were meant to be realized in real life. And that the fact that you are in a public office is not a dress rehearsal for the play that is coming. It's actually the play itself. So I do think that it provides us a very good opportunity to set a precedent so that those of us who are seeking public office, especially in this new institution called devolved government, will take our responsibilities seriously with regard to the Constitution. And this has been the concern of this committee. And that's why we have been saying that although we thought we had a solution, we needed to bring you forth so that we would know that this is some kind of solution that we share. I would like to summarize it like that so that tomorrow we have this meeting. In the meantime, our secretariat should write that letter very, very clearly to the IBC, to the EACC, and to the DPP, and the AG. AG is very important to be here. AG, DPP, EACC, and IBC. And then we shall finalize the matter. After that, whatever decision the IBC makes, I would say that the cross is now yours to bear after our meeting tomorrow. Is that clear? Yeah, that should be clear. So thank you so much, ladies and gentlemen. Thank you very, very much for coming. And we'll meet you tomorrow. Of course, the Auditor General, you will be here Chairman, too. Yes.
Even as you wind up the meeting,
yeah,
you remember you had not rotated an opportunity for us to ask the other institutions. Allow me just, they can come and respond tomorrow.
Yeah.
The Office of the Controller of Budget. The question I wanted you to answer is, why have you, without even as little as raising a finger, continued to allow disbursement of funds to Kakamega County in view of the outcry everywhere, from the Senate, from the Office of the Auditor General, from the Office of the DPP? He has actually recommended prosecutions, and you continue to recommend for disbursement of funds. You want to answer tomorrow?
You can answer now. Yeah. Proceed. I thought you did try to answer it, but I don't want to take your responsibility. Go ahead.
Thank you, Chairman. I think based on the Constitution, Article 225 is very clear. It vests the responsibility to stop transfer of funds to counties in the Cabinet Secretary responsible for National Treasury. So that is the institution that is vested with that mandate to make a decision. And when they make that decision, the mandate of the office is to come in and undertake investigation. But even when the Cabinet Secretary has made that decision, the only stoppage is the tune of 50% of what account is entitled to. It's not complete stoppage. It's up to about 50%. Then within a period of 30 days, the controller of budget comes in to undertake investigation, makes a report to Parliament, and in this case, Senate, whether that suspension should be withheld or lifted. So we've never encountered such a scenario, but just to answer to your question, the mandate for stoppage of funds is vested in the Cabinet Secretary responsible for the National Treasury.
Mr. Chairman, not so easy. Not so easy at all, because this is one of the reasons why we have been dying to have Oparanya here to respond. According to the internal audit in Kakamega, they are equally perplexed that you don't raise a finger on this flow of cash in spite of the questions. And you know, as you officers come to face us, because we wanted to put this to Oparanya, we'll now put it to you. There is information which we have reason to believe that some officers indirectly at the Office of the Control of Budget are doing big business with the county government of Kakamega. So you'll need to respond to that. It's not as easy as you want to think.
Chairman, can I make a comment?
Yes, sure, yeah.
Yeah, I think mine is just an observation that every time Mr. Tobiko, the DPP, comes here, he leaves us with a legislative challenge.
Yeah.
Because the way I'm understanding is, if I get him correctly, these things are there in this small book, but it would be much better, much easier, much smoother, much easier to quickly act. The route to be more direct and get action quickly, IBC to be told this in no uncertain terms, if we get a way of anchoring it in some statute or the other. And I think that challenge, I think as a parliament, we need to take it up. Because wherever I look at it, you end up with small splits, somebody goes and claims something or other, and that little gap, you take forever even to come out, such that some of these governors, Mr. Chairman, will run away with billions and billions, and we don't know even where to get them 10 years from here, just because of a small gap where, if it was in a statute where action, for example, if we said somehow, I believe we can, that although the person to stop the disbursement is the Cabinet Treasury, if we do it in such a way that the advice or that can be instituted or can be started by Senate or by Parliament, such that the action is this, then it becomes easier. Even if we go to court, we don't go round. Thank you, Mr. Chairman.
Thank you. I want to bring this meeting to a close, but I'd like to request Honorable Ndema to introduce himself, to be on record that he attended this meeting. It's very important. Yeah.
Senator Andrew Ndiema, Senator for Trans Nzoia County, and a member of this committee. Sorry, Mr. Chairman.
Thank you, Henry. Finally, what the DP, just as a final comment, what the DPP has pointed out, that there are various parts of this constitution which, if we made legislation in line with those constitutional provisions, our work as an oversight committee will be much more effective. I think this is something that we shall recommend to the committee coming in. Fortunately, Senator Karwe, even if that law is made in the next Senate, and finally some governors who are in office today are caught up in that law of having misused public funds, we are actually rescued by Article 226 5, which says, if the holder of a public office, including a political office, directs or approves the use of public funds contrary to law or instructions, the person is liable for any loss arising from that use and shall make good the loss, whether the person remains in the hold of the office or not. So we recommend to the next Senate to make sure that these laws are made and that those people who think they want to get away with public funds, there's Article 226(5), which will still be enforced when we are all out of the Senate. Thank you very much, ladies and gentlemen. We meet tomorrow. I think we meet tomorrow at what time? What time do we meet tomorrow? So that the letter is very clear. 9? So that they go knowing. Yeah?
Chairman.
Please.
Inspector, I think we need confirmation because, for example, IBC, she cited the CEO, you need to confirm. So
yeah, but
we say 9, as we have no problem, but the other...
Yeah, and if we say now, then they can go and prepare for the appropriate time. Yes?
Chairman, just in respect to the comments that have been made by Honorable Kalwale,
yeah,
we want to indicate that as an office, we really uphold integrity at the highest possible level. And in the event that there's any information with confidence, you bring it to the attention of either the controller of budget herself or EACC, that is the body mandated to undertake such issues, we will actually take action. So in confidence, it can be anonymous reporting to the controller. Sometimes that necessitates you make an anonymous report to her. We will definitely take action on those cases. We will really appreciate to get that information as an office.
I was not going to do it anonymously. I was going to put it to the governor when he was now responding to oversight questions. So it will help. You don't have to wait. What we have said is on Hansard. It's now a record. You are now sufficiently provoked. But if you want me to do it, then I will not do it anonymously. I'll do it and write and sign and do it in public because we are fighting corruption.
Okay, Senator Luale, let me say the following. I would encourage an interaction between you and the Office of the Controller of Budget on this issue. I think it is good they have opened up. They say they received the information. You have also opened up. So do them a letter detailing these things, and then we can deal with it. The issue can still come back to this committee once it's raised. So tomorrow, can we have the time? 10 o'clock tomorrow.
Sorry, Mr.
So
Chairman.
yes,
Chairman,
sure, yeah.
Just one small issue.
Yeah.
I was wondering whether perhaps it's the chairperson of the commission you should invite. Maybe he might be of better help than the CEO.
The chairperson of the
Yes,
commission,
yes,
and comes with the relevant officers, including the CEO.
Yes.
Because usually when we invite chairpersons, they must come with the accompanying team. So you and the CEO should accompany the chairperson coming here. You particularly because you are here today, the CEO because he was the original invitee to come. But the chairman we shall invite. Yeah, thank you. Tomorrow 10, we meet here. Thank you, on the dot.
Well, that brings to the end of this meeting today, a consultative meeting that has been there between the Committee on County Public Accounts and Investments Committee and some of the stakeholders that are involved in this business of accountability, be it at the national level or at the county level. At this particular meeting, they were discussing the case that is Kakamega County and then an appearance of Governor Wycliffe Oparanya in this committee, and it has become a thorn in the flesh as senators have been insisting that his appearance at this particular committee has been crucial in trying to understand the monies that have been forwarded to the county of Kakamega, and him not appearing has actually caused accountability problems that have been a problem not only to the people of Kakamega but also to him. It is also said that in some instance he has one audit query that runs up to 214 million shillings, and these are some of the accountability questions that he should have come here to answer to. One of the other matters that has really irked the committee is the fact that he has been called twice, that is 2 years in a row, and he has actually not attended this committee. The chairman of this committee, that is Professor Anyang' Nyong'o, has actually called another another meeting tomorrow, another consultative meeting tomorrow that will be including the chairperson of the IEBC and other relevant organizations like the DPP, who will be coming here to get a conclusive answer as to what action will be taken against Governor Oparanya. You'll remember that the IEBC has been insisting that they will be having interagency meeting, or one is already on course, whereby they will be discussing this matter about Kakamega and actually and other matters with regards to all the aspirants that will be tendering in their nomination papers, so as to get the way forward. This committee wants Governor Oparanya barred from holding public office. This is 75 days to the elections, and they want their voice to be heard as much as possible. You remember that this committee has been calling some governors to come to accountability. They have been able just to be able to look into the financial year, that is 2013, 2014, and 2014, 2015, which has just started the other day. But they say that the poncho with which these governors are not attending to what they have been called to is becoming a big problem. Other governors had also called on, had also said that they will not be attending this committee, but with what has been happening, or with the summons that this committee has also been offering them, they have actually come forward and said that they'll come forward and appear before this committee. But it has become a problem. Now, the DPP, who was at this particular function, has also pointed to some grey areas that this committee needs to explore, and they did not know that they do have those powers. One of the provisions in the Constitution that have been pointed to is Article 193, that is Section 2G, whereby the DPP has informed this committee that it can actually make a recommendation that Governor Oparanya not hold any public office, and forward that recommendation to the IEBC so that it can be considered amongst other reports. So it is something that we are waiting to see. And the consultative meeting that has been called for tomorrow is really important with regards to the direction in which this committee has taken. Earlier on there, it had taken a decision on Governor Alfred Mutua, whom they had actually walked all the way to the office of the Inspector General of Police to call on him to come before him and actually frog march him to this committee. The next day, Governor Mutua was brought here. So they are being told that they do have powers to make these recommendations, and only if they do trust in themselves, they will be able to make these recommendations that are binding. It will be interesting to watch what will happen with Governor Wycliffe Oparanya. One of his critics is his senator, that is Boni Halwale, who has also declared interest in becoming the governor of Kakamega. So it will be interesting to watch how events unfold with regards to this committee and with regards to Governor Wycliffe Oparanya, now that he has actually been given a direct nomination by his party ODM to contest in the governorship for Kakamega. So we'll be keeping tabs on what is happening, and tomorrow we'll be here to inform Kenyans of what decision this committee takes if all of those who have been invited to appear before it come and exchange ideas on the way forward. Back to you, Trevor.